our law and licensing committee meeting with a special focus on our UPAC processes and procedures. Let's just do roll call, and then Board Member Lear.
Oh, I'm here.
Okay. Vice Chair Bollinger. Board Member Longacre.
Here.
Board Member Hall. And I'd like just to put on the record that Deputy Superintendent Nui is online. It's my understanding that Board Member Lear has a few documents that she would like to produce and share with the committee digitally, or they have been shared, just wants to acknowledge those. So, Board Member Lear.
Do you want us to use mics? Are we supposed to use mics? Okay. I just received these documents when you received them this afternoon. Is that what you're referring to? I sent an email, forwarded an email that I received from the General Counsel of UEA, who reminded me about more than several, less than many documents that give a lot of institutional background to our discussion that as I said in my brief note to you folks, I'm sort of embarrassed that I did not call to our attention earlier. But and I don't have copies. I mean, some of these are more than 100 pages long. Some of them are more like 6 or so. I would just ask you to read that email that I forwarded from Tracy Watson, General Counsel of UEA, and look at those documents. They will give you more background than you ever wanted about these discussions we're having, and I think they inform them very importantly. And they illustrate the history of reviewing this process. This isn't a process that was invented suddenly and not looked at again for 20 years. It's been reviewed almost every 5 years for the last 15 years or 20 years. So I just would encourage you to look at them. If you want them printed, you can do that. They're all public documents. So that's really all I have to say. I couldn't begin to summarize them today. But I just really appreciate Tracy Watson for reminding me and gathering them all, which was no small feat, and then forwarding them to us. And if you want more individually, if you want more explanation or background of the documents, I am very happy to, meet, to discuss it at some later meeting. I just got them when you got them. So I'll discuss them at some later meeting or discuss them with you individually. So that's what I have to say. And then also Tracy's email kind of provides her insight about the process. So I hope you can read that and process what she offers.
And Board Member Lear, was there a second individual that you wanted to introduce an email or records from?
Only that I know that Heidi Alder, who's an attorney with the Weber School District and also represents other LEAs, had sent us an email. And Heidi did not send it to me directly, but sent it to all of you. So I hope that you will also read and consider what she has to offer. She's been involved with UPPACC in very many roles, starting as a hearing officer, interestingly, in the early 2000s, and now has had different roles since. And so she also offers some helpful information. And those two individuals were not able to be here.
Thank you for that. We received a request from Board Member Lear and Vice Chair Bollinger asking that several individuals be able to share their experiences and observations with the committee tonight. I've been asked and agreed that 5 to 10 minutes, that's not a firm timeline or timetable. If you need more, that's fine. But we won't let you speak any less than no. So you have 5 to 10 minutes. If you need to go over, that's fine as well. The order that the committee loosely, or I should say Board Member Lear and I loosely discussed, would be Cass Harstadt would go first, then Ezzy Kasanya, close, thank you, and then Joe B. Wright, who will be joining us online, then Travis Cook, and then we'll conclude with Terry Francis. Does that accommodate everybody's schedule? Not seeing any objections or hearing any.
Joe, one more question on,
Please.
would it be all right? And when I contacted these individuals, they were willing to answer questions as long as those were appropriate, not about cases that are still pending or for which are not final. But would it be okay if after they make their comments that we have questions if anybody on the committee has questions?
Yeah, I think that's fair. And what I'd suggest is each individual comes up, they speak for the allotted time, they share their experience or observation or what they want us to know as a committee, and then the committee members, if they have any questions, answering questions is not mandatory; it's not part of the process. But if you're willing to do that, I think that'd be wonderful. Okay, thank you. So with that, let's start with Cass Harstadt, and ask you to come up to the table. You'll see a button, looks like a person talking. Press that, your light should turn red. And then just state your name and if you're with any particular organization.
And I assume it's okay if I sit. You don't want me staying. It's. So thank you very much for allowing me to come today to talk to the committee. I have been an attorney since 2000. I've been representing teachers in front of UPPACC since, I think it's 2011, it may be 2012. I represent anywhere from 10 to 15 in a heavy year, maybe 20 educators a year in UPPACC. And I've represented teachers, the whole spectrum of teachers. I've represented teachers who've had their cases dismissed. I've represented teachers who have voluntarily relinquished their licenses in lieu of revocation. I've participated in hearings. I've done the investigation. I've done expedited hearings. So I've been doing this process for about 15 years, and I've actually gone through a few iterations of the rules. And have participated and have been a stakeholder in previous revisions to the rules. So in looking at the process kind of on a global level over the last, I'm going to say 5 years, one of the biggest problems that we're having now is that R 277-217 was amended a few years ago, and so everything is getting reported to UPPACC. Now, every parent complaint, every violation of an educator standard is getting reported to UPPACC. And that has led to a relatively large backlog. And you sort of think, well, every educator standard that's violated should be reported to UPPACC. These are very general, broad standards. So every parent complaint, even unfounded ones, are reported to UPPACC now. Some of the standards are you have to treat a student with respect. So if a parent or a para or a child comes home and says, this teacher didn't treat me with respect today, that can theoretically be reported to UPPACC. Another one that I've had in the last year is not providing truthful information on all applications. Now that seems like it should be reported to UPPACC. In this circumstance, it was a teacher who accidentally checked the wrong box. He hit yes rather than no, or no rather than yes. It was literally an error on the computer. So things like that are getting reported to UPPACC. A lot of times these will go through an expedited process, but in several, maybe 4 or 5 of these instances in the last year, they've gone to full investigation. So I've had a teacher, I had a teacher this year who swore at students on, I think, one occasion, maybe twice. It was high school students. Or he maybe said a swear word under his breath as he was leaving the classroom. It went to full investigation. He ended up getting a letter of education, which is something, it's a letter from UPPACC saying you haven't violated educator standards, but you're getting kind of close. But in that year, he couldn't transfer. If he wasn't employed, he couldn't get a job because your cactus file is flagged. This teacher who accidentally clicked the wrong box on his application, he got a letter of education. And he was under a full investigation. It took probably a year. And he was unemployed for part of that. So it was a big deal. So the change to 277, 217 has actually, it's really negatively affected educators. And I don't think that it has helped promote having teachers follow the standards, because the teachers that wouldn't have every sort of significant violation or violation that warrants the UPAC investigation was getting reported previously. So to me, that change has led to more problems than has been helpful. I do want to say the UPAC investigative process at the UPAC level is generally pretty fair. The investigators are very, very good at their jobs. They're fair. They're really willing to work with the educators and with us. They're engaged. It is not unusual for me to get on the phone with an investigator and talk about an individual's case for 20 minutes, a half an hour, 45 minutes, talk about the law, to talk about the facts. So the investigators you have a good group of investigators right now. The expedited hearing process, I really like. Those are, if somebody is accused of a lower level, a lower level violation, like the swearing at a student, that probably should have gone to an expedited hearing. And if it goes to an expedited hearing, usually the educator will have a hearing within a couple months and they can get the flag off their cactus file. So it's fast and it's effective. And it also allows the educators the opportunity to actually engage with UPAC members, which is something that's important, because this is UPAC and the board are making decisions outside of, the educators aren't there when they're making decisions, and a lot of times they don't meet with UPAC at all. But the investigative process is good because an educator can get there and explain their side of the story to the UPAC members, and it is helpful. It's transparent and it's helpful to the educators. Even those full investigations are generally relatively pretty fair. We get to see the investigative reports before it goes to UPAC. We can make, suggest changes. We can say, hey, you didn't consider this, you didn't consider that. We think this is overemphasized. The one problem with the full investigations is they take too long, and that's the result of the change to 277, 217. The biggest problem that I have come across in recent years is when UPAC recommends one decision or one discipline, and then the board doesn't accept it and changes the discipline. This is a really big deal. So as an example, UPAC may recommend 1 year suspension. Now, the regs say 1 to 3 years is presumed appropriate if a teacher is engaged in A, B, C, D, E. The difference between a 1 year suspension and a 3 year suspension for educators is critical. So teachers that have been suspended for 1 year, I've represented some of them in their reinstatement hearings. They will sometimes, a lot of times they don't, but sometimes they do come back to teaching. Once a teacher's been out for 3 years, I've never seen an educator come back from a 3-year suspension. So having the board say, well, UPAC recommended 1 year, but now we're going to give 3 years, that is a very, very big difference to a teacher. And it's the difference between the teacher likely coming back or possibly coming back and not coming back. The thing that's concerning about it is it's the regs say, and the due process says that the board can only consider what is considered in the UPAC investigative file. the law on due process makes it clear that an educator is entitled to know the allegations against him or her, and they should have an opportunity to respond to and challenge that evidence. So when a board, like in my case where the my recent case where the discipline was changed from 1 to 3 years, it was a pretty well publicized case, and I don't know if board members considered if they considered newspaper articles, if there were emails that were sent. And so if things like that are being considered by the board, that violates the educator's due process rights. And it's really concerning to me, other attorneys that represent educators, and the educators themselves. Um, it's also the lack of transparency is very confusing to the educator. So you're told, you go through this investigation process. UPAC takes a year, they interview you. Sometimes UPAC comes back and interviews my clients 2 or 3 times. I had a UPAC case 10 years ago where there were depositions. So UPAC does a thorough investigation. They're trained, they're, people who are trained to do this, they're educators, and it's statutorily mandated. And so, meeting with your client, you can say, okay, here's the matrix, here's the regulations, this is what UPAC is recommending. And the educator feels somewhat, they understand that. And then when the board, you go to a meeting, there's executive session, an hour later, the board comes out and they talked about, I don't know, 30 cases in an hour. And all of a sudden they've gone from 1 year to 3 years. It's very disorienting to the educator because it means they probably have lost their livelihood. And it's also hard for me to understand because we don't know what the reasoning is. So the lack of transparency and is very concerning. And also we worry that the educators' due process rights are being violated. I know that, like I said at the beginning of this, I've participated in some of the amendments to the rules as a stakeholder. I think at this stage, a complete overhaul of the regulations is going to do more harm than good. A lot of this process works. The UPAC investigation process works, the expedited hearings work, a lot of it works, and it is generally fair to educators. I think there are some adjustments that can be made. I mean, there are little tweaks like scheduling expedited hearings is overly complicated. But those tweaks, I think, need to be made with stakeholder input because I was talking to Izzy about this yesterday, and there are things where she's like, oh yeah, I don't like this. This is difficult. I hadn't even thought of it. And she's right. And so even two attorneys that represent educators, we're going to have different input and feelings on all of this. So I do think that you need the input of stakeholders. I also think that this needs to be data driven. For example, I am curious to see how many educators come back from a 1-year suspension versus a 3-year suspension, because I think a 3-year suspension is the equivalent of a revocation. And I don't know that the board knows that when they are making those decisions. I mean, if you have a teacher who has been a teacher for 25 years and is going through some very stressful thing in their personal life, they have cancer, they're going through divorce. I think if the board knew, oh, if we do 3 years, this teacher is never going to return, maybe it would be different. I just think that we need to look at some of this data before we make massive changes to the regs. I'm happy to take any questions. I don't know if I've taken up way too much time, but I'm happy to answer any questions if you have any.
You came in at 12 minutes and 13 seconds, so you're fine. Any questions from the committee? And it doesn't you don't have to ask all your questions. If you do, that's fine. But if you just want to ask a few and then others ask, that works too. Board Member Longacre.
I appreciate everything that you said, and I kind of had a couple of aha moments with some of the things that you have said. Question for you. I heard that this data is captured, if you will, but we don't see it. So maybe on the cases that do come to the board, if we saw that this was a unanimous decision and all of you were on the same page, or only 7, or maybe that would be helpful. Is that something that could be on those cases that we get?
Well, so I don't sit on UPAC, so I don't know how they record their votes, or whether it's consensus. So that's maybe a question for somebody else.
Any other questions? Board Member Lear?
I had one clarification that, and I'm asking for this because I thought it was one way and maybe it's changed, and since I have not paid as close attention. My recollection was that when the expedited process was added, and that was probably 10 years ago, close,
Yeah, probably.
something like that. The idea was, the rationale was, if it's a very lower level offense, let's take care of it quickly. Let's not keep people hanging on, and that was part of it, and that was the main impetus. I thought you said, but so my recollection was one of the kind of advantages also was because it would be taken care of quickly, we didn't need to flag the cactus file if it was an expedited hearing.
My understanding is the cactus file is flagged until the expedited hearing is determined by UPAC and then the board. So you'll have an expedited hearing. I mean, that depends. If it's a letter, if it's anything above, I guess I don't know.
It's above a warning that.
Yeah, I
it's
think if it's
flagged.
above a letter of education,
No, above a letter of warning. If it's a reprimand or higher,
Right.
it's flagged.
but during that investigation, my
Mhm,
understanding
okay.
is the cactus file is flagged,
And-
even for those few months.
And Joanna's shaking her head, but I just think that might be something to revisit and clarify, because to me, it seems like a good trade-off to say, we're going to take care of these quickly, so they don't need to be flagged. And they're a low-level offense. It's not, so I don't know. We probably need to make that clearer for everybody, the attorneys, the board members,
Yeah, my
staff.
understanding was always that during any investigation, even prior to an expedited hearing, the cactus file is flagged, because sometimes you'll have an expedited hearing that will then go into full investigation. So
Right.
Can I address that just
Uh-huh.
briefly?
Please,
Just
Director
to explain,
Rasmussen.
with expedited hearings, there are 2 types. If there's a criminal charge, the educator's cactus file is flagged. For cases that are reported by LEAs for misconduct in the classroom, if we do an expedited hearing in those cases, we don't flag them unless we open an investigation.
I just would hope maybe going forward that would be a little clearer for everybody involved, because that what you said makes sense and the rationale makes sense, but I didn't know the distinction.
Well, and I mean, I will do 3 expedited, 4 expedited hearings in some months, and I always assumed that once you got that letter, your file was flagged regardless of whether it was expedited or not.
Thanks for that clarification to everybody.
I just have a few questions, and one was on the flagging of the cactus file. So one of my concerns is, and Director Rasmussen, if you could correct me if I'm amiss on this, but only certain types of cases qualify for an expedited hearing option. Is that correct? And it's my understanding those
Yes.
typically are those where the predicted outcome would be a letter of warning or less, or letter of reprimand or less. Could you help me understand that?
The general criteria are that there shouldn't be substantive disputes as to the facts. The educator should generally still be employed, and it should be something that we anticipate that the presumptions would be for a letter of warning or less.
Okay, and if I wanted to find those in code or rule, where would I go?
R277-211.
Okay, thank you. So as soon as the facts are in dispute, they no longer qualified for an expedited hearing. Is that correct?
Yes, simply because we try and keep those to half hour or less, and it's hard to do a disputed hearing in that kind of time frame.
Okay. The other question I had was, you cited that sometimes the board will come in with a higher um, decision than maybe what was recommended by UPAC, and that troubles you at a certain level. When the board makes the decision to reduce the recommended action by UPAC, does that trouble you as well, or was the focus more on the impact on the educator? Does that question make sense?
Well, that troubles me as a parent. So I have a child, I have a daughter in school age. Because I think UPAC is a team of experts that have chosen to do this. They're statutorily mandated. They take the time to review the cases. So I think the situation in which a recommendation from UPAC is changed or rejected should be very, very rare. Because I will say that in the circumstances in the last couple of years where something has gone to full investigation, where it seemed more appropriate for an expedited hearing, or where discipline was not accepted by the board, they seemed to be political button issues, and I don't think political hot button issues should play a role in an educator's discipline. That's not me speaking as an attorney, or I mean that's more as a parent. But so anytime the board changes discipline from what UPAC recommends, it's concerning to me because I know that the board has to be the ultimate decision maker, but UPAC has dedicated time and resources. They have very good investigators. They are the experts. And so we really should be relying on their recommendations.
Thank you. You talked about,
Joe, can I ask a follow-up to that?
Yeah, please.
Just briefly. So I guess the part that I just heard you say, and you said it just again, so I just wanted to call attention to it. I guess the thing that troubles me the most about that change of description, or the change of discipline in either direction, is that it's a mystery to the individuals involved, and that bothers me. Whether it's the parents that, and they wouldn't have known the recommendation anyway. But if it's the educator and the attorney, then they hear what the recommendation is, and then all of a sudden it's different, and they have no rationale to compare with other situations.
Yeah, and I also think you also don't know from the outside what is being considered. And so as an attorney, that is the point in the process where I'm the most concerned about the educator's due process rights, because it is absolutely unconstitutional to consider anything outside of what's been presented to the educator. That is 100% a violation of the educator's due process rights. And so that's very concerning. But from you call an educator and you say, well, I know UPAC's recommended 1 year, it's 3 years. Well, why? I have no idea. And that the lack of transparency is a big problem at that stage.
yeah, I would agree with that. I actually talked about releasing the hearing report to the public so everyone has more transparency on the issues, the facts, what's happening. So I think transparency is absolutely a good thing. Just one other set of questions. You talked about this increase in complaints due to the changes made to R277, 217. Can you estimate for us the increase in the number of complaints which have been filed with UPAC because of that change? Because you said it's contributed to this delay. Can you estimate for me how many complaints have been filed?
I can't, because I only get, I'm called in to represent a certain number of, like I can limit the spigot to me. But I will say that prior to the last 2 years, I have never represented somebody who ticked the wrong box on an application. I'd never represented anybody who got in trouble for saying a swear word. I had never, I represented a teacher who had an iPad sort of smack a kid because, she was holding it and it went like this. 2 years ago, I never would have represented somebody in that situation. And I think her case was dismissed. I don't know if her case was dismissed, I think, but it was still a 2 or 3 month process.
And do you know if the three examples that you cited, and I agree they seem trite, I don't know all of the facts, but on the surface, those three cases you cited, did they arise because of the change in 217, or were they filed by the district? Like, were they UPAC motivated? Does that?
Oh yeah, they were motivated by the district, but the district has to report. I think the districts feel like they have to report everything. And so some of these complaints were maybe parent complaints, maybe 3 of them in the last year, but it's what the district is reporting. The bar has been set so low that I think the districts think that they have to report everything just to be safe.
So these weren't decisions, to your understanding, made by UPAC. These were filed by the district because of this change.
Correct.
Okay. And then Director Rasmussen, let me ask you, because of this change to 217 over the past, I think the change was effectuated in 2024, how many complaints have now come to UPAC that otherwise would not have because of this change in 2017?
I don't have the numbers in front of me. I would clarify though, there have been a couple of changes to the reporting. There's been back in, I think it was about 2017 or 2018 that we did the most recent task force, and that's when the requirement was updated that all substantiated violations of the standards had to be reported. And then recently, about a year and a half ago, the board updated for the parent complaints to be reported, and we've provided that data in the past. I don't have it in front of me.
Is it over 10,000?
No, it's not.
Well-
Okay. Is it over 1,000?
No, it's not.
Is it over 500?
I've provided the data in the past. I don't have the numbers.
If we took a break, Director Rasmussen, would you be able to pull up that data in the break and report that to us? Because I want to make sure that we're not being inundated with these numbers. So is that something you could access if we took a 7-minute saunter?
I've got
Okay.
a question though to that point.
Yeah.
And Cass just made me realize this. I don't know that Ben always knows because the district reports a complaint and the district doesn't always say this came from a parent. It says we have this complaint and the district, Granite District says we received these 5 complaints and it may not report to Ben's office. This came from a parent. This came from this came because of this. This came because of this. So I am a little reluctant. I don't care if he finds the data, but I'm reluctant to say that's dispositive because we don't know how clear the LEA was in reporting to Ben where the complaint came from.
And that may be an area that we can focus on again, but let's take a 5-minute break, see if Director Rasmussen can come with the data of how many of these have come up since we made the change a year and a half ago. 5 minutes. Thank you.
5. Can I time it? Because I got to get out of here at 7. I'll time it. Well, yeah, I have to be someplace else by 7:30. Takes me a minute, but there we go.
In early 2024. And it shows that there have been 133 classified as unsubstantiated parent complaints in that 2-year period.
So when we talk about this wave of complaints that are coming in because of the change, UPAC, should I say the director or UPAC has assessed that number to be 133 over the past 2 years?
Staff has assessed that.
Staff? Okay.
Chair, may I ask a question on
Please.
that? So my understanding, this is specifically from parent complaints. Do we have a graph that shows how many complaints? Because what we heard here is LEAs also have to, if there's any kind of perceived violation, it's not just the parent complaints that now have to be referred because of the change in code and law, but it's also anything that could possibly be considered a violation of the standard. So I'm wondering, do we have data to show even just our UPPACC referrals over time and not just specifically the parent
Yes.
piece?
Yes. And that's the reason that we're dealing with a great number of cases, is because those referrals have gone substantially up.
Okay.
So
Thank
the
you.
LEAs are actually filing more complaints against educators.
LEAs, parents, you name it.
But if they're parents, wouldn't it be reflected here? Or this is just those attributed to the change in law?
These are complaints submitted by LEAs that have been classified as unsubstantiated parent complaints.
Okay, thank you. Carol, Board Member Lear?
I just think this is really something we need to flesh out better. And I wanted to add that I've talked to a number of individuals, HR people, as well as attorneys working with LEAs, and LEAs vary considerably. Some feel like they need to review those complaints before they're submitted. They feel like they have the right to. Others literally send in every single one. So I think we have 160 LEAs with 175 standards. And the complaints, it says, and the code are supposed to come from the LEA, but we don't know which schools report, which don't report. So I worry that data are incomplete because of so much of different definitions.
Okay. Yes.
So by way of example, I just recently had a case in the last 6 months where a parent sent an email to a principal that said, I don't want anything to come of this. I just want to make you aware that this is happening. But we don't want a complaint. We don't want any discipline. I just want to make you aware. That ended up getting referred to UPPACC, and this educator had a full investigation, and his cactus file was flagged for a year, and he got a letter of education. So that's a good example of what Board Member Lear is saying, where it's that wasn't even a parent complaint, and it still made its way to UPPACC.
No, and I think that's fair. I think Director Rasmussen, a conversation we had, I don't know if it was before the committee or one that we had offline, but out of all these unsubstantiated complaints that are coming in, where the district has decided to take no action, how many has UPPACC decided, well, action is warranted?
I don't have these numbers in front of me.
Okay, that's fair enough. But it was relatively small, single digits. Is that correct? Or you don't remember? Okay, thank you. Thank you, Ms. Harstadt. Izzy, it looks like you're next. Thank you. If you could just state your name and place of employment.
Sure. My name is, oh, this picks up pretty well. My name is Izzy Kausanga. I work for the law firm Skolnick, Thorne, Holland. I actually used to work with Cass for a good amount of time. Just a bit of background about me. So I do not have nearly as much experience in the rural development side of education law generally. I did start taking educator cases almost immediately upon practice. So I've been doing UPPACC cases since about 2021 pretty consistently. In addition to educator cases, I have my civil litigation cases. I have also represented educators through certain claims outside of UPPACC, like negotiating with LEAs, in some cases litigation. So it is, and it's an area of law, of course, I enjoy. So I want to echo what Cass has mentioned, which is I do think that the UPPACC process at the UPPACC level functions well, and I work with the investigators pretty consistently, just like Cass, and I have the same relationship. I can pick up the phone and we can talk about the facts of the case, similar to a civil case that I would have, because I am familiar with the teacher's case and the investigators are familiar with the facts of the case, including in their conversations with the district, witnesses, review of documents. We, you know, I am talking to the teachers directly and they are talking to the districts directly. And I think it's worked out to be pretty collaborative. So and forgive me because I'm going to go through this really fast, but I think this is important to give context to what I want to talk about, which is what I would tell a teacher who just got a UPACC letter, right? So I tell them UPACC is in charge of investigating potential alleged violations. And once they get a notification, usually a couple things can happen. They can choose to take no action, they can choose to do an expedited hearing, or they can choose to do a full hearing. Once that choice is made, if there's no additional information, you can't change that, right? So if something goes to a full hearing or a full investigation, excuse me, it cannot be switched to an expedited hearing. But if it's an expedited hearing, it's possible that if more comes out, it needs to be more serious, it could be a full investigation. So you, teacher, will talk to the investigator. We can give the investigator information, and then the investigator does not make a decision on your case. The investigator presents that information to UPPACC, who then makes a recommendation that ultimately gets approved by the board. You may have the option to go forward with a hearing, but ultimately the board makes the final decision, but you will not talk to the board and you will not talk to UPPACC. So that is the general framework that teachers, I think, understand at the outset, right? And I'm happy to talk more about that, but I think you guys are generally familiar with that as well, right? So one of the, again, going back to what Cass said, I don't think that an overhaul of the rules is necessary. I think that there are some amendments that could improve the process as well. And I think part of that comes from what I've seen as some general concerns. So what I mentioned to you about the fact that teachers don't talk to the ultimate decision makers, it's really hard for teachers to hear that, right? It feels less fair, and their only option for potentially challenging witnesses directly is to go forward with a hearing, which is within their right to do, but not a decision that they can take easily or lightly, because it can prolong the process. It can be costly to them, not just in terms of money, but also their efforts, their emotions, and all of the stress.
Izzy, can I ask you a question? How much would it typically cost an educator to take a matter to hearing for a 2 or 3 day hearing? Just in attorney's fees, what would that cost?
I think it varies depending on the attorney. Sometimes there's insurance that can be provided related to that, and it depends on the complexity of the issues. So unfortunately, like an attorney, I would say it depends. But I think I can give you like the cost it would be for my regular rate to do a hearing like that at a higher education level is closer to about $20,000. Like a that would be a general assessment.
I understand. It's ballpark. Okay, I was just curious.
Yeah, don't hold me to it.
Too late. No, you're good. Thank you.
Great. So, the concern, again, to summarize that point, is that I think that these teachers, the further the decision gets from who they see and who they're telling their story to, you can imagine the less fair it could feel, right? And so the teachers talk to the investigators directly, but then the investigators don't talk to the board directly themselves. And similar to what Cass was saying, the reasoning for this, like if there's, like if the board wanted to remand it, it doubles on top of that feeling of unfairness, because we maybe have a general idea of why it gets remanded, but there's no official record of why it does, no reasoning, no way to ensure consistency or fairness in that part of the remand process. And then so the point that I think Cass made, that you asked about, I do think it is more in terms of the teacher side, more it comes up when the remand is more severe. And I do, as I mentioned earlier, the investigators and UPPACC are closer to the actual facts of the case and can understand some things that I think get nuanced, that I think can be lost in the communication. And the investigative file, of course, is what the board should focus on, but the investigators are the ones who are assembling that, and the attorneys are the ones who are contributing to that, and neither are at the table for the final decision. My second concern, again, going to sort of what Cass was mentioning as well, is that the discipline that's being issued, and this is my anecdotal opinion, of course, I think is pushing good educators out of education. I have seen a lot of educators get 1-year suspensions. I don't think very many of them decide to get their license reinstated. And the individuals who do decide to get their license reinstated don't go back into education. Teachers are most of the time more critical of themselves than other people are of teachers. So when this happens, they very much challenge their place in the classroom. Again, similarly, there are a few teachers who go into education because it pays well. They do it because they enjoy being in the classroom, and if they are suspended and told, you can't be in the classroom for a year, you can't volunteer in a classroom for a year, they most of the time say, well, I guess I'm a horrible teacher and should never go back in the classroom. I also think that the weight of even a reprimand can often have the impact of a suspension. So, for example, if a teacher ends up getting terminated by their district related to the incidents, but UPPACC issues a reprimand related to it, that teacher would be unable, in almost 90% of cases, they would be unable to find an alternative position while that reprimand is on their file, which I have only had situations where the reprimand lasts for 2 years, right? And so it depending on the length of the investigation process, that reprimand is on their file from sometimes a year to a year and a half after the final decision on the reprimand. They're unable to find a job in education, so they leave education. And similar to a suspension, once they've left education, they have they almost come to terms with the fact that they maybe were not meant to be in education. That's sort of what the mindset is. Despite my urging of, no, you're a great teacher, and even through the UPPACC process, they get that assurances from UPPACC as well. So I think that these levels of discipline have a very intense effect on the teachers themselves. I don't think a reprimand is a slap on the wrist for a lot of teachers. In some cases, I think that it's almost necessary. It is necessary in many cases, but in a majority of cases, I've seen that the discipline ends up having an over effect, right? It's more severe than I think was needed to correct the behavior.
Are you willing to take questions?
Yes.
Okay, Vice Chair
Chair,
Bollinger.
If I may, through the chair, just a question on, and maybe this is something that you wouldn't be able to answer. I'm just curious, as we've been talking about now that every complaint gets reported, are you seeing individual teachers seeking representation even for things that end up not really going to a case, or are they really only seeking your legal advice or your representation if it's going to a hearing?
So I represent, that's okay. I represent clients not just for expedited hearings. It's usually the investigations. If there's no UPPACC letter, like I think the UPPACC letter informing them of an investigation or a potential expedited hearing triggers the representation or the desire to seek out representation, both in frankly a union context and a private context. I wanted to make one other point that through this process, and I hinted at this earlier, there's very little room for negotiation in this process. I work with the investigators. I have had the privilege of being able to call Ben directly. I hope he will not think that I'm taking advantage of that. But whatever we may decide or whatever gets decided at the UPAC level, always at the end of the day, we'll have a check off from the board. And I have not been able to negotiate, and I understand that we can't negotiate any usual of the material terms of the consent to discipline. The language in the report maybe, but the length of the discipline, the classes associated with it, the additional requirements. Once that's in the consent to discipline, there's no negotiation on that issue. It's either the teachers can accept this or they have to go forward with a hearing. And although that in itself is the teacher's leverage, the hearing is the leverage, the power dynamic between teachers and the UPAC process and with schools as well is just so vast that many times teachers don't feel like they have a choice, right? And again, the hearing is more than just potentially the cost monetarily, but the time it takes to get it scheduled, the effort of potentially having a flag on your educator license for an additional however 6 months potentially, right? It's not the teacher at that point who already has ideally reflected on what they've done, have potentially been disciplined by their LEA already. They don't feel like that's really a choice to them. So that, again, I do think that there's room for improvement. I don't think that there's an overhaul. I also think, like Cass mentioned as well, it's important to get multiple viewpoints on this because at the end of the day, one thing that I've noticed is that everybody has the same goal, which is we want good educators, right? I don't think that anybody's going to say otherwise.
I just have two questions. One on an area you didn't talk about, but we've talked about, and that is the application process to be an educator. Have you ever represented anyone in that scenario?
I have not.
Okay. And then we talked about teachers quite a bit. Have you ever represented administrators at a school in a UPAC setting?
I have represented teachers with administrative endorsements, and I've represented a very few number of administrators in a non-UPAC setting, but not in a UPAC setting.
Okay. Thank you. Vice Chair Bollinger.
Just one question. You mentioned that you feel like there is some room for improvement. If you were to say, magic wand, here's some things that you think could have improved, are there one or two or however many things that you think that we could be doing, or in either whether it's in rule or in process, that you think would improve how we do things?
I think that some avenue between the teacher and the board, the final decision maker, some sort of way to access that. It shouldn't be unfettered access, right? But I do think some way for the teachers to have some communication with the board that's not so disjointed, I think would make a big difference. I'm reticent to propose more because I have not gotten all the stakeholder input and I don't want to overspeak on that front. But the other point I would make is more emphasis on the training and education piece for teachers. Again, like I said, I think that the discipline oftentimes does more than its intended purpose, and to really influence teachers, I think there are less severe methods because there are exceptions to this, but a majority of teachers are, I will never do this again. And most of the time they don't, if they return to, if it's a reprimand and they return to teaching, it's rare for me to see them do it again because they are their harshest critics. And the way that we understand that educators are dealing with a really tough environment to teach, I think that they understand that as well.
Right. Board Member Lear?
I just have a comment to that, to your comment, and that was interesting that you brought it up because my experience has been both on the board and then before, when I was more in your line of work, it was that shoot, I lost my train of thought, and that was so important. No, never mind. It'll just pop back into my head and I'll come back to it. But it was related to the fact that no, let me just try. That teachers are, as you said earlier, they're worst critics, and they are. I think there's sometimes a board or a perception by the public, or sometimes even board members, that these teachers are rushing to get back into the profession, and they can't wait, and they don't learn anything. But and it came back to me. What I would like to see, what data I would like to see, instead of my just anecdotal recollections, is that how many teachers who actually receive a reprimand, for instance, how long do those people keep teaching, or do they keep teaching? Because I think we have a misunderstanding about how forceful this process is on teachers. So that's one piece of data, Joanna, that I would love to see, is what are the real numbers of teachers coming back following a reprimand and or lesser discipline.
Yeah, and I will say that I would like to see that evidence too. My anecdotal comment on that is the educator reinstatements that I have done, none of those teachers returned to teaching. They wanted to do it so that they could volunteer, and sometimes they would pick up maybe like a coaching type of role, or like a volunteer for, like certain clubs, right? But they didn't return to full-time teaching.
Thank you. I just make a statement as well, and that is, you are an attorney. You represent your client, who it sounds generally is the educator, but this board is also in charge, or charged with, protecting the students and protecting public education. And one thing that is much more difficult to measure is, what is the impact on that student or that child that loses their innocence? What is the impact lifelong on that child or student who is exposed to, I was going to say drugs, but really anything that would be inappropriate? And so we have to weigh that in the totality. So as we're looking at the impact, I think it is absolutely essential for us to get this balance right. And that requires us to look at the impact on the student who are exposed to inappropriate videos, pornography, language. So again, I think that what UPPACC owes the educator and teacher is due process and fairness. And my concern is we don't have enough of that in the system. So I think we can do both, and I think we need to do both better. But I want to thank you for taking the time to be here on a Tuesday night. So thank you.
Thank you all. And I agree as well. I think that fairness is associated with due process. Those are synonymous in my mind, and the balance with the students, right, is also the important part.
Thank you. So next would be, I'm going to say Joe B. Wright, because that's how it is in the notes. I don't know if it's Joseph. Oh, you have it as Joe B. Wright as well. So Joe B. Wright will be joining us via Zoom. So Joe, if you could just tell us your name for the record and your occupation, and then take 10 or 15 minutes. And if you're willing to answer questions, I'm sure the committee will have some.
Thank you, Chair. I appreciate that. My name is Joby Wright. I'm the Executive Director of the Southwest Education Development Center, which is the RESA located in the southwest part of the state. Our office is in Cedar City. And we work with 6 districts and 9 charter schools. I am also currently a member of UPAC. I've been able to serve on UPAC since July of 2022. So I just finished my first term on UPAC in July and started a second term by being reappointed. I just wanted to know how I came to take up this opportunity, and I appreciate it very much, the opportunity to speak, and appreciate the opportunity to do it via Zoom so I didn't have to travel the 3.5 hours up to be there in person. I apologize that I'm not there in person. As I was listening to board meeting last week, I heard that there was going to be another committee meeting to discuss UPAC. And I have been hoping all throughout this process that at some point some members of UPAC might be invited to share some of their thoughts. And so I reached out to my board representative, board member Green, and said, I am willing to participate in the committee meeting on Tuesday if that would be needed or acceptable. And so thanks for the opportunity. I reached out, and then I also offered a couple of other names that maybe would be interested in being here tonight. I just want to share really quick and briefly kind of what my experience has been as a UPAC member, and then I would be very open to answering any questions that the committee might have. It has been my experience that everyone who is a member of UPAC is there to protect all stakeholders. And it doesn't matter whether it's an educator or a community member or an administrator on the panel or on UPAC. Everyone there is trying to think of what is best for everyone involved. I have to admit that originally when I signed up to be on UPAC, I thought that I might be the one, because I'm a licensed educator, I thought I might be the one trying to protect licensed educators. That's not the case, and that's not necessary. Everyone there is there to do what's right for the educator, for any potential victims that there might be, for the system at large, for the community at large. Everyone has a very broad perspective of what we're trying to accomplish by either using discipline or choosing not to use discipline. I know that there's been some discussion tonight and in the past probably about changes made to R277, 217, specifically section 5-2A that was added in January of 2024, I believe, where LEAs now feel the responsibility to report to UPAC and to the educator any allegation of a violation. So it's not whether there was a violation or not, any allegation of a violation. I think that's one of the reasons that we've seen an increase in the number of referrals, both through the hotline and from LEAs. I don't think it's the only reason. I think that we've seen an increase in the hotline use as well. Just our society has changed a little bit, and people are expecting perhaps more accountability or are making more accusations, however you'd like to phrase that. So we just see more referrals. My anecdotal thoughts on that is, and I don't have facts or data to back that up, but as a UPAC member, it feels like we are looking at about double the number of cases each month that we have the first year or two that I was on UPAC. I don't know if the data supports that, but that's what it feels like, is that we're going through about 2 times as many cases each month. I know that there's been some concerns raised about confidentiality and conflict of interest at the UPAC level. We really do our very best to make sure that everything we discuss as UPAC stays there at UPAC. We receive the files with enough time to review them, but as soon as we have reviewed them and as soon as the meeting of UPAC is over, those files are taken out and we don't have access to them anymore. So we don't have access to go back and review previous cases from months and months ago or anything like that. And for the most part, none of us look at written copies, hard copies of those files. Most all of us access them electronically. And so as far as confidentiality, we do take as many cares as we can to make sure that what we discuss in a UPAC meeting is confidential. And I have observed that anytime a UPAC panel member believes there is any type of conflict of interest that they may have, maybe they have additional knowledge that's not contained in the report, they are they take it very easily to recuse themselves from the discussion and from the decisions. I myself have recused myself, stepped out of the room for certain cases where I felt like I had too much information, maybe that was not in the report, or maybe I was just too close. Because I have relationships with a variety of school districts, 6 school districts and 9 charters in the Southwest region. It doesn't happen very often, but sometimes I have to recuse myself because I'm just a little too close to the situation. I think that educators have multiple checking points throughout the UPAC process to make sure that they feel like they're receiving due process. At any point during the process, they can request a full hearing. Now, I understand that there may be some financial barriers to that, but I'm always surprised how very few educators actually request a full hearing. In the 4 years that I've been on UPAC, there's been very few actual full hearings. Most everything is handled through expedited hearings and through investigative reports. And the educator has an opportunity to stipulate to that, or they can choose a full hearing. The only other thing that I wanted to bring up is I understand that there may be some minor tweaks that would be beneficial to the UPAC board rules, but I would just urge the committee and the board as a whole, if there's going to be any significant changes to these rules, that it would involve stakeholders, that it would probably be best for a task force that would include all stakeholders or representatives of all stakeholders if there was going to be any significant changes. And with that, I'm open to any questions that any of the committee may have about my experience with UPAC.
I don't see any lights, Joe, so it looks like you're off the hook.
All right, thank you so much.
Thank you.
Thank you so much for the time. Can you hear me? So I've got some notes here, and a lot of it's been covered, so we'll just hit some finer points.
Travis, if you could just state your name and who
absolutely.
you
Yep.
work with.
Travis Cook, I'm an educator creeping up on 30 years. 18 of them spent right within the confines of this fine institution. Yeah. More specific to my comments today, I served as a member of the UPACC Commission 2019 to 2023. At the time, I was the Alternative Education Administrator in Provo City School District. Most of my career was spent at the intersection of the legal system and the public education system. Juvenile courts, I was a court interpreter for a very, very long time, youth courts, et cetera, et cetera. When I was appointed to UPACC, I was quite pleased to note that the approach both by staff and by the committee reflected what I had seen in other court environments, other legal system environments. In fact, there was a very clear reverence for the process and a deep understanding of the lasting impact the decisions that were going to be made would have on students, educators, and the broader education system as a whole, which has been talked about a little bit here already. In all the UPACC hearings that I participated in, and I participated on both sides, right, as an administrator and as a UPACC member, they were court-like, formal, but they were personal and were conducted with professionalism and respect. So the strengths of the system as it stands right now is that you have educator-informed decision-making, ensuring that the recommendations reflect practical classroom experience and professional norms. You have very structured procedures, rules, clearly defining, I think, what are we up to, 7 board rules, 5 to 7 board rules that reference UPPACC already, that are driven by this committee and by a board that are regularly reviewed. Those are strengths. I think if there's anything I've heard that would be an opportunity for improvement, a lot of that stems from the relationship and the tension that exists between an LEA's employment authority and UPAC's licensure role. Those things can be very easily confused at every level. And in both situations, acting quickly or waiting both carry legal, ethical, and perceptual consequences, right? I was never keen during my membership, during my appointment, on an LEA referring a matter to UPPACC and then waiting on the outcome, effectively allowing the statewide process to carry the weight of the decision. Having said that, there's also a realization that LEAs come in many shapes and sizes, with many diverse bandwidths, if you will, and capabilities to do really good work in the human resource space, or lack thereof. So that's something to consider as well. To further extend that point, UPAC's role versus the local LEA employment actions, there can be misconceptions about responsibility or fairness there. And Ben can speak to this. I really beat this drum. The idea of prevention, the opportunity to train, the opportunity to embed more formal trainings within annual vector solution type experiences and expectations for teachers to reduce the referrals that were coming to UPPACC. I myself, as an administrator, you can talk to any of my faculty, how many times we went over the UPPACC newsletters, or they did so on their own and then brought any questions that they might have back, so that we can have really clear understanding and discussions around what's appropriate, what's not appropriate. That, as we know, that needle is constantly moving and is constantly being adapted based on the rules that are written in this room or approved in this room. The only other thing I think I want to touch on is where we go from here. In my personal opinion, I'm a strong advocate for incremental revision and continuous improvement. The existing framework of UPPACC benefits from decades of experience and input from attorneys, experienced educators, and an extremely well-represented roster of current state board members, right, who understand both legal and professional standards. Carefully updating specific rules allow the board to address gaps while preserving the procedural safeguards and professional expertise, minimizing disruption, redundancies, and maintaining the continuity for educators, students, and the community. I myself can't think of a body more suited to do this work than this committee and the current board, especially if you were to lean and leverage some of the other expertise in other similar public systems in Utah, Doppel, Post, the State Bar, etc. With that, I'll take any questions if there are any.
Vice Chair.
Thank you, Chair. Through you, Chair, if I may have a question about, it seems like you have a pretty good understanding of due process and in different settings across different legal settings, I guess I should say. What are your thoughts on our current processes and procedures, and do you feel like they provide due process for teachers?
I do. In fact, the due process components of our current rule system include notice, obviously, neutral decision makers, the burden of proof, opportunity to present evidence, record keeping, and a tiered review process that includes the board itself. So I do feel pretty comfortable with that due process, given what the structure of the commission is designed to do. Yes.
Oh, sorry. I didn't see your light. Go ahead, Board Member Lear.
One of the things that I am trying to hope this is not revealing anything I shouldn't. So, but one of the things that when we have discussions of UPAC cases with the board in the closed session, one of the things that I sometimes concerns me that sometimes board members don't know or see is that UPAC members discuss the cases we discuss for maybe 3 or 4 times as long and as thoroughly, even if there's no hearing. And sometimes the board's discussion is 5 minutes, or unfortunately, sometimes it is longer. Maybe not unfortunately, but sometimes it is longer. But could you, and I could have asked this to Joe too, but could you just walk us through what a discussion of a case looks like in the UPAC committee?
Absolutely, and especially during my tenure, right? I tended to be kind of an outlier in
Yeah,
terms.
you may have taken longer when you were there.
Yeah, just because I think there are some things that need to be really debated. I mean, that's the advantage of having an educator-informed process, right? What are the best practices? What are relevant in today's classrooms? What is relevant in an alternative setting? What are educators actually experiencing? And so I think that's wrestled with. I think it's debated, in some cases hotly debated.
So be really specific, Travis. Like, so Ben brings the case.
Yep.
You've got what kind of information in front of you?
We have the same information that he has access to,
which
which is the details that have been provided to you
by the investigator.
Absolutely. And so that's prior to the investigation. And after that, we have all the details. Right?
And then you sit in the meeting, and then what happens?
Well, then we read files for multiple days prior to preparation for the meeting, and then we hash out to a word level whatever's in those files to determine if and again, we had the luxury of having representation to further align to make sure that what we're recommending aligns with what the rules dictate should happen. But other than that, we are absolutely debating the merits of every single case.
So an investigator is in there while you're talking about it. Is that right?
Yeah, we're all in there.
Yeah. And then, so how long does that discussion take on a typical case?
It's a great question. It's been 2 years removed. So I mean, sometimes we're there for many hours. It just depends on how many cases are coming through on a given kind of docket, I guess is a better way to say it. I do think the expedited process helped significantly, and it continues to help significantly to lessen the burden of that work. But it's still it's time intensive for
And
sure.
then one more just follow up to that
Mhm.
explanation. And so when you conclude as a committee,
Mhm.
did you just personally, and I know this is personal to you, but did you like most of the time feel like comfortable with the recommendation, or all of the time? Or
Such a great question. For the most part, there was only one case particular that I had any significant angst with. But eventually my angst was resolved down the road. So I was in all the time I served, I felt very comfortable with the recommendations that were coming out of that body. And some of them weren't easy, but I did feel very comfortable. And that's not necessarily been my experience in other legal systems.
Thanks. Okay.
Yeah.
Thank you.
Thank you. I have a question about due process. Are you familiar with a subpoena-only non-disclosure agreement?
Mm-hmm.
Do you think that impedes in any way the ability of the respondent in a UPAC hearing to express their side or version of the events if that individual is not subpoenaed to appear before a UPAC?
That's a great question. I think for me, this comes back to one of the points I was trying to make and another opportunity to make that point, which is I do think there could be some work done to provide that information to those parties to make sure they understand fully what their rights and opportunities are within the process. Again, this is extremely prescriptive, the way this is governed currently. Are there opportunities to maybe be more clear in that regard? Possibly.
So I don't know if that's a yes or no or a maybe.
That would be a big maybe.
Okay.
Because it also depends on what representation they would have as well throughout the process. And to Joe's point, it is a little bit remarkable that there isn't more representation sought by all respondents.
The other question on due process I have is, in your opinion or experience, is there a fundamental conflict? It's my understanding that UPAC does not have a written conflict of interest policy, which I think is a due process problem. It's also my understanding that there's no written privacy policy, which I think is a due process problem. And again, my goal here is to increase due process for the teachers and educators in the system, but understanding that the system is designed to protect students with fairness and due process towards the respondent. In your experience, is there have you ever observed, well, let me ask you, and you may not, it says here from 2017 to 2023, you were a UPAC member, is that correct?
2019 to 2023.
2019.
Yep.
How many administrators did you see coming through UPAC during that period of time?
Such a great question. A handful, probably, with some for sure, but I couldn't tell you exactly the number. But to your previous question, and not only are you interested in that, I as a member of the commission would have been very interested in an opportunity to not only disclose any conflict of interest, but to basically protect myself formally in that regard and in a privacy regard as well. So I don't think that's outside of what's good practice by any means.
So from 2019 through 2023, you're saying you saw a handful of administrators come through the UPAC process. And what primarily were the reasons they were being processed through UPAC?
Without getting into details, the ones that are coming to mind would be probably related to truth disclosures of some kind. I'd have to look back at the newsletter. That's the benefit of the newsletter. We could go back and look at all sorts of specifics relative to those cases if necessary. Is there something specific about administrators that you're interested in?
No, I just think that a lot of times as I talk to individuals who've gone through the UPAC system, my concern is that administrators investigating themselves always strikes me as a bit unfair to the students that this body is designed to protect. So that's really what I'm getting at. But I appreciate that it's difficult to go back and
Right.
recollect. Let me ask you this question. I've had numerous complaints or concerns, I should say, from people who've gone through the UPAC system. And they talk about that initial investigation and the investigator's recollection as recorded on the investigative report is different than these individuals who I've spoken to. And that's understandable. But what really struck me is that these individuals who've reached out to me don't know each other, but they all say the same thing about what went awry in that investigative hearing. There's a commonality. And that I wasn't ready for. I was ready for the, you say tomato, I say tomato, but how they all gravitate towards the same concern of what I believe went wrong in that investigative hearing. Given your experience, is there any reason why we should not require those investigative hearings to be recorded?
That's a great question, and not one that I'm prepared to speak to. I mean, from any legal perspective, I don't know why they.
But putting legal
Yeah.
aside, just given your UPAC, is there any reason that you can think of, given your experience, why they should not be recorded?
There would be no reason for me personally to object to being recorded during a UPAC hearing that I sat on or I was a witness to.
Investigation, yeah.
Just so I understand the question you're asking, you want the investigator's discussion with the individual recorded?
Sure. Can you think of any reason why we
So
shouldn't do
I
that?
wouldn't be involved with that. But anything that would be, I mean, akin to a court-like experience in other systems. I don't know that outside of deposition, I don't know that, I don't know, I don't know of other scenarios where that might take
You
place.
got an
You don't
issue.
think so?
Well, meaning,
If you go to
uh,
Walmart and shoplift, they record you.
you might
If
have
you're
a-
charged by the police, they're
You
recording you.
might
So
have an attorney-client privilege issue if the attorney is there consulting. And I'm not that experienced. I'm not that in that kind of law enough to know if you
Mhm.
might have an attorney-client privilege issue there if it's recorded and others listen to it. I don't know, maybe.
yeah,
Cass
I just,
could-
to answer your
Yeah.
question directly, me personally, would I have a problem with the work that I did 2019 to 2023 being recorded? No.
And do you see any issues with, and again, I'm not saying as an attorney or
Sure.
as an expert in this, but
Sure.
just generally, given your experience with UPAC, do you see a detriment to the process if we were to say, look, we have these similar complaints coming up from people who don't know each other? They're all saying, they really shouldn't have done this. And can you see any detriment to the process?
I may be speaking above my pay grade, but I personally, I wouldn't have a problem with it, no.
Well, thank you very much for coming in today. Any other questions from the committee? Okay, thank you. And yeah, no, don't.
Just in terms of and you may have said this, but in terms of weighing the general fairness for respondents versus the public, the school system, do you find, what do you find about the balance between fairness for both parties involved there?
I feel the system is quite balanced. Again, to speak to that, the disconnect that I do see and have seen is a relationship between the LEA's employment
Uh,
processes, right? Versus there's it gets convoluted in that regard, right? Like where was the property where was the property right during while I was employed, or if I'm no longer employed, where does it stand now versus where the property right stands when I go through a UPAC process? Those are two very distinct things, and sometimes they're misconstrued.
yeah. Thanks.
Board Member Lear's question, it sparked a question in me, which is, have you ever, that's a bad. Yeah. I don't know how to frame it, so I won't ask it, but I appreciate the balance between the employment and the licensure. So I appreciate you bringing that up. Thank you. And then the individual that I have listed to our final guest is Terry Francis. Terry, you know the drill. Name and place of employment, and you're good to go.
There we go. Thank you. My name is Terry Francis. I'm grateful for the opportunity to be here tonight. I'll follow Joe's lead and tell how I came to UPAC. Back in 2018, 2019, I was a member of the Utah PTA Board of Directors when we were approached with a request for someone to participate on a task force. I volunteered for that. So I was on the task force of 2019 when a community member seat opened up in the spring of, or was about to open in 2020. I expressed interest in that. So I became a UPAC member in the role of community member in July of 2020. So I'm in my final year of my final term. I have a career history in school administration and human resources. And as a PTA leader, I have experience in advocating for parents and teachers and students. So I feel like UPAC is my groove. I love it. So that's my history. That's where we are today.
Thank you. Do you have a statement or something you want to share, or just field questions from the body?
I didn't prepare a statement like Joe and Travis. I'm willing to take questions. There are a few points I'd like the opportunity to express, perhaps at the end, if I'm allowed. But a number of the points I wanted to share tonight have already been expressed, and I can concur with many of the things that have been said, and would would elaborate on those if wanted. But I'm fine with taking questions first.
Board Member Lear?
First of all, I've got two then. One, was there anything that you have a different perspective about than what someone else tonight expressed?
No, I would elaborate on many of the points that have been made. I found myself nodding in agreement quite a bit from the first speaker to the last. I likewise feel that the rules are, in general, fair to all stakeholders with regard to how UPAC and staff employ those. I'm very proud of the work that we do on our commission. Our preparation and discussion are intense. In preparation for every meeting, we read between about 500 and over 2,100 pages. The preparation involves not just reading that, but referencing the standards, checking the presumptions, comparing with similar cases on the matrix, all of that. I write down my questions that I have with every case and points I find particularly outstanding that I want to discuss, and come up with a preliminary proposal that I would make. In the meetings, we discuss at length. I feel confident that every single time we discuss a case, we hash it out completely. I feel that if even one person, I don't feel that, I know that if even one member on the commission wants to keep talking about it, we keep talking about it. If I am the only one in disagreement with where it looks like we're going in terms of a recommendation, I have no qualms about speaking up. I know that my fellow members will hear me out, and not just hear me out, but take me seriously. If I'm the only one who wants to open a case can get opened. So I feel like every voice is vital and heard, and that we have no hesitation about exploring every bit of material that is before us and looking at it from all angles. And even though our composition is vital in terms of 2 community members, 9 educators, and those educators being in various roles and levels, I feel that, like Joe said, we all look out for all stakeholders. So I'm wishing I'd brought my water up here.
Oh, right there. That's what I put that there for.
Thank you.
And I thought everybody else looked more thirsty than they. Can I just follow up to that a little bit? I want to get to the last question I asked Travis too. But one thing that's not come up today that I think is an important issue for me in observing the discussion in closed session. You've had the experience of, because I've seen your name on these hearing reports, but you've both participated in the discussion for a, what we used to call a stipulated agreement, but now it's a consent to discipline. You've seen that discussion, and then you've also been on a panel for hearings, right? I'm sure
Correct.
many times.
Many times. I particularly like participating in the hearings. I love the opportunity to hear directly from an educator and to ask my questions to make sure that I have all the information I can have before deliberating on that. And I like the opportunity to question others involved in the case too, like the administrators that show up in a hearing. I think that the hearings are an extremely effective and important part of the process. And frankly, I'd like to see ways to expand the hearing arena, either increase the boundaries for expedited hearings or find other ways that we can use hearings to address even more cases.
And do you find, and now I'm trying not to lead you anywhere, but when you see the difference between the discussion with UPAC and then the hearing, does your opinion sometimes change of the situation, or are usually your first inclinations consistent with, and then I'm also asking as a piece of that, is it help to observe, talk with the respondent, as well as hear about them in the discussions when things are a consent decree as opposed to a hearing.
I was going to
process.
ask you to clarify, but I think I'll just address both possible answers you could have given.
Okay.
When I participate as a panel member on a hearing, uh, we deliberate, obviously, and come up with a recommendation to bring to the full commission. Then that full commission will discuss our conclusion. We as panel members have the opportunity to explain to the rest of the commission members why we reached that conclusion. What is our justification for doing so? Likewise, when I'm not on a panel and in full commission meetings, when hearings come to us that I did not participate on, like I said, we discuss this. In both cases, I think that I'm not an elected spokesperson for our commission, but I feel confident that everybody on the commission is comfortable challenging those initial recommendations and asking further questions, and really making sure that they have reason to agree or disagree with the panel's recommendation. There have been times when we've recommended a change to that. I think most often we support it. Does that answer your question?
Yeah, very much. I just was interested in your experience in the two different places. And then finally, this similar to the question I asked Travis, do you feel like, and I think you're a particularly good person to ask because you are the representative from a representative from the community perspective. You're not part of the system. So do you feel like there's a fair balance between due process for educators and an opportunity to tell their side of the story, and then also the other side of protecting students, making sure the system has integrity, and do you feel like there's a fair balance, or do you think it's leans one way or the other?
I do think there's a fair balance. I also think that that's partially because of the members that we have, and that could be different if the entire member body was consisting of different people. We have an excellent dynamic right now, I think. Because my role is community member, I do feel a heightened responsibility to represent the parent perspective. And as I said earlier, I'm not afraid to speak up and say so, and I'm heard when I do so. I don't feel that there's any unfairness with regard to how educators are represented or considered compared to how parents are.
Thank you. That's helpful. Thanks.
Vice Chair Bollinger.
Thank you, Chair. If I may follow up on that question about due process. So the whole UPAC process as we currently have it, do you have any concerns about due process for our educators going through the process from the beginning to the end, and or not? I'm just curious to know your thoughts on that.
I absolutely do. I am deeply concerned about one point in the process, and was surprised to hear someone else actually mention it tonight. As I said earlier, in preparation for our meetings, there's a lot involved. There are days of reading, lots of consideration, references, all kinds of things, and then long discussions. It was asked earlier how long we discuss things. Sometimes it's moments if it's a felony case regarding sexual misconduct with a child. There's not much gray area in that. However, last month we discussed a case for an hour. It depends on the complexity of the case. It depends on the questions we have, the perspectives we bring, and all of the factors that are included in the material that is before us. And we don't conclude until we're done with that. That being said, I feel very strongly that anytime the board wishes to consider a final decision that differs from that which UPPACC has recommended, that it should employ at minimum that same level of due process. Or it should always remand back to UPPACC with specific instructions on what to address. When we deviate from a presumption, we justify it. When we come up with a decision, we align with those standards. We check the matrix, we check the presumptions. We care very, very much about getting it right every time. It bothers me deeply to see final decisions that differ so greatly from our decisions, especially when it's clear that the same things we considered were not considered in the final step. I think that's a tremendous disservice to educators, to the community, to students, to really everyone involved. So that bothers me deeply.
Thank you, Chair. May I follow up with another question I have for you? We've talked quite a bit about the difference between complaints coming from teachers or parents and those filed by LEAs, whether that's through the hotline or through, just an LEA referring. And I know we've kind of thrown statistics around that there's a really high percentage of cases that may just kind of be rejected before they get investigated if they're referred by parents versus if they're referred by teachers. Can you help us understand why there's a disparity there from your perspective or as you see those cases come in?
First of all, I think that I'm confident that the statistics I've seen on that are very misleading, and for a couple of reasons. As was said earlier tonight, a lot of the complaints we get from LEAs are originally parent complaints. When parents submit allegations independently, often those are not things that would fall within the remit of UPPACC. They're not under our purview. They're not what we say in meetings, they're not UPPACCable. They may be, for example, a student is playing with a pencil in class, using it to disturb other students and disrupt the lesson. Teacher asks the student numerous times to stop doing so. The student does not comply, so the student quietly takes that pencil away from the student and continues with her lesson. Parents upset because that pencil was the student's private property and the student was sad when the pencil was taken away. This is not something that we address as a body, something like that. Or perhaps the parent is not happy with the dynamic between their child and another child and doesn't think the teacher's doing enough to keep them from interacting on the playground or something like that. There are a lot of things that upset parents that are simply not issues that we are authorized to address. They're not violations of the standards. So those would not be cases we would open.
If we talk about room for improvement, and this is a question I've asked a few other people, where do you see room for improvement, or do you see room for improvement throughout our process or documentation, or where do you feel like we could do better? I mean, we've talked about, we've heard from a few other people about continuous improvement. That's something that I think we're passionate about as board members, is to continuously improve our process to make sure that we are serving our students and our teachers and our community.
I'm very glad that you asked that question because I'm passionate about continuous improvement too, and I tend to seek ways to improve things. So I do have a list of ways that I think we could improve. Most of them are minor. One is that final board decision. I think that that's probably my paramount concern. Another concern I have is with regard to educators. I think that there should be a rule that allows educators the option of remaining confidential from their employers when reporting misconduct. This has been a concern for me for long enough that I reached out to 20 educators that I know. I purposely selected people at varying levels from the very top of districts to classroom teachers, and 16 of them responded to me. So I talked to them about this topic. Every single one of them said one of the following: either they themselves has experienced retaliation or has not reported for fear of retaliation. They have firsthand seen it happen, either the retaliation or the reluctance to report, or they currently would not report because of the threat of retaliation or the likelihood of retaliation. So I think that there are things we can do to improve that. Educators are the front lines. If there's misconduct, they're probably going to see it first. And we need them to be confident and secure in upholding the ethics of the profession in the same way that we strive to do so on this end. So that's something I'd like to see. I think there are things we can do to automatically collect data so that we can use that to figure out where to direct our efforts. I realize we can't just hire more investigators, as much as I would love to see that, but I would like us to find ways to allow them to focus all of their professional energies on investigating. They're probably the best people to create and conduct training, but probably other people can do that too. We only get 3 investigators. And this case list that we have is ever growing. And it does concern me how long educators have to wait for a resolution. I feel like that's not fair to them. And I'd like to find ways to allow our investigators to prioritize that fully. I think there are a lot of things we can do. And I hope that everyone's willing to work on that.
Chair, if I may, I just have one final question. Can you help us understand? So we talk about this matrix all the time. Can you help us understand how that helps you with cases? Does it give you enough information? Do you feel like anything needs to be updated with that, or speaking on continuous improvement? Can you speak to that, please?
I should first admit that I really love spreadsheets. So I think they know that. The matrix is an extremely valuable tool because we can't necessarily remember everything. And of course, we can't know what happened before our terms began. So in the interest of consistency and fairness, we need that matrix. We need to be able to reference it and make sure that what we're settling upon is consistent with what's been done in the past.
Sorry to interrupt you, but could you explain, maybe for the 2 other board members, what this matrix is? Is that something you can do? You want Ben to do it, or is that is that something that's helpful to you? It feels like that movie, you know.
If I may, as
I'll
part of
take you off the hot seat.
as part of our settlement agreement with UEA several years back, we agreed to maintain a list of each case that comes through the board process. And so the spreadsheet that Terry loves so much outlines what happened in each case, what the UPPACC recommendation was, what the board ultimately did. Also shows what all the aggravating and mitigating factors were considered in the more serious cases were. So it's basically a way for UPPACC to compare cases we're looking at now to similar cases we've had in the past.
Thanks. That's helpful to me too.
It's helpful to us as a tool to be able to reference all those things.
I cut you midstream, sorry.
That's okay. I think that as part of a much bigger system, we could improve the matrix by creating a big system that affects everything from the tools that are used to report allegations of misconduct to the final decision. We can create very simply, even using Google Forms, a standard form that every person wishing to make a complaint uses, that is filtered based on their role in the situation, that feeds automatically into one universal spreadsheet, that then feeds out to a matrix for the public, and a matrix that doesn't have to be a different matrix for UPPACC, but it could potentially have even more information that we could have at our disposal, though I can't offhand think of anything else we need than what's in it. And that could also affect the workload of our staff back there that has a lot to do. I think there are very simple things that we can do, even free, that can allow for the data collection that's been expressed in all these meetings as vital, that we can use to identify trends, to focus our training, and improve whatever aspects we need to, and keep everyone informed too, because the matrix is available to anyone who goes to the USBE website. Educators have access to that. Their attorneys have access to that. So I think it's a valuable tool that we need to keep in place.
Thank you. I just have a few questions. Do you have a list of the number of complaints that each district files with UPPACC?
No,
That's not on your spreadsheet?
no.
Okay.
And LEAs, I guess you can
Yeah, absolutely. Do you have any of that information?
I don't have that information.
Okay. Do you know if UPAC has that information?
I do not know what they have that I don't have access to.
Okay, fair enough. Um, Ben, you've got to whisper quieter because if I can hear it from way up here, that's a bad sign. It's not a good whisper. Um, you talked about this delay and how, and these are my words, due process requires that we move these cases faster to a certain degree. Would you agree with that?
I do. I have to say that I don't pay particular attention to the length of time that a case takes, with the exception of when we need to consider that as a factor in determining our proposed discipline. So I don't keep statistics in my head about how long that takes. I know that our case list a few months ago, our investigators were excited because we thought we might actually get under 100. And the last I heard, it was up around 140, and I don't even know where it is today. So um, I wouldn't be in favor of reducing reporting requirements, for instance, but I do think that we need to give some serious attention to addressing the open cases and trying to find ways to process them as quickly as we can for the sake of educators who are out there waiting.
I agree. My question is, when Utah decides to prioritize a matter, it's slated to be heard 6 months in the future, and then the decision is made we're going to bring it up to next month or 2 months from now. Is that decision, is the explanation for that decision recorded anywhere?
Not that I'm aware of. I don't see it if it is.
Okay. And I don't know the answer to this question, but your answer sparked this. Is retaliation actionable under our educator standards?
There are mentions of retaliation in the standards. However, those don't protect educators in the first place. And I think that's a valid concern for educators to worry about that.
Yeah, let's talk about that because you talked about, and I was curious because I've never heard this before until you mentioned it. Maybe a process or a system to allow educators to report anonymously, and I can see the wisdom in that. I can see some challenges, but absolutely something worth looking into and really vetting that. When UPAC receives an anonymous complaint from our hotline currently, that anonymous complaint can be filed by an educator, a teacher, parent, student. What is the process? What happens when UPAC gets that anonymous complaint from our audit hotline?
I don't think I'm the appropriate person to answer that question. However, I do know that anonymous complaints are often not actionable because we don't have anybody to contact. So even if we were to consider some kind of protection for educators, we need to still be able to talk to that educator.
I guess my question is, what happens to that anonymous complaint? Do you know or not know?
I don't necessarily know, and
Okay.
I don't necessarily know.
And obviously, the anonymous complaint doesn't include the name of the individual filing it. But have you seen anonymous complaints come through UPAC?
I can't think of any.
Okay.
I don't know for sure. I don't think so.
And something you said, the language you used, you talked about that pencil case.
Yeah.
And saying, hey, we're getting cases like this. And you use the language, we would not open that case. You really can't open that case. Isn't that correct? Because it has to be a violation of educator standards for UPAC to consider the matter.
Exactly. That's the first thing we consider. If this is true, if what is alleged is true, would it constitute a violation of the standards? If the answer is no,
you can't open it.
It's not something we can open.
As you said, it's not UPACable or
it's not UPACable.
Right?
Yeah.
So I just want to make clear that UPAC is only taking those cases. You could have a non-licensed educator, an employee at a school who shows child pornography. That wouldn't be actionable by UPAC if they don't have an educator license, correct?
Correct.
So it's not just the the small pencil issues. It's the major issues, which we've seen in the news recently. UPAC doesn't have jurisdiction over those.
Right. We have a defined jurisdiction.
Okay. As I've looked at files, as Director Rasmussen has brought files to me and I've looked through the actual file, one thing I've noticed is that I don't see in many files an independent investigation being conducted by UPAC. What I normally see is reports from the district, and then I see an investigative report summarizing the investigation done by the district. When UPAC conducts its own independent investigation, could you tell the committee what does that mean? Like, what is happening in the independent part? Because primarily I'm seeing this is what the district did. I see not even a transcript. I just see a summary of, we talked about maybe recording as a possibility this investigative hearing, but maybe a transcript would be enough. But we don't even have that. We have a summary of what took place. So when we say UPAC investigated this matter, what does that mean generally? I know every case is going to be nuanced in it, but generally, what does that mean?
To me, that's an indicator of quality, for one thing. I think it needs to be
In
recognized
what way? When
that
you say quality, what do you mean by that?
I'll get to that. Okay.
Okay.
I think that we need to recognize that not all LEA investigations are equal. Some are extraordinarily well done, and some are pathetic and shameful. And in fact, that's an area I think we need to address. Training LEAs on how to conduct investigations that are objective, thorough, and fair.
Who do you think should conduct that training?
USBE in some regard.
But
think that
should
we,
UPAC be? I'm asking because you have an investigative arm. Do you feel that with the right resource, I'm not saying you have to pick up another task without the resources, but is that something you think UPAC should lead?
I think it would be appropriate because our investigators are highly skilled. They know how to conduct good investigations, and that's the quality piece I'm talking about. I know that when they've done an investigation, that it's been done objectively and thoroughly and fairly. I've gained that confidence just through the experience of 5.5 years. LEAs, we can't expect every administrator in the state to know how to conduct a proper investigation. Even recently, we had one LEA investigation where the assigned investigator was an individual directly involved in the incident. So that's a conflict of interest, obviously. There are times when I'm very concerned about their interviewing process, their selection of witnesses, and various things like that. I think that we could do a lot to help our LEAs do a better job in that regard. I don't want to put another task on our investigators because I really want them to focus on the case list, but they probably are the most skilled and appropriate people to create and conduct such training.
Okay. I have no further questions. Does the committee have any? If not, Board Member
I did
Lear?
have a comment, this would be an interesting discussion to pursue, Terry, because I think on employment issues, if the board found that there's not adequate investigation by LEAs, it seems to me the board's role would be to say to LEAs, I'd start small and maybe work up to this. I don't even know, but I think that it'd be important to urge LEAs to do better employment investigations. I don't necessarily think it's the board's role to take on even the training for local investigations because those are employment issues that are specific to LEAs. And, if wishes were fishes and we had 10 more investigators, then some of them could be assigned to training and some of them could be working on cases. But I am just concerned that I think LEAs it might be the board's role to encourage LAs to do better employment investigations, but in the end, I feel like it's an LEA's job to figure that out and clean up their acts. I don't see it as the board's role to tell them how to investigate their sweepers.
I don't want to declare, who should do something, but I don't know what resources would be out there for LEAs to do that. Another thing that you made me think of when you were speaking is that sometimes we encounter LEA policies that directly conflict with state laws or administrative rules or our standards. And these are things that need to be addressed too. I don't know who should do that, but clearly somebody needs some help somewhere. So I think that it's worth a discussion anyway.
Sure.
Thanks for letting me make that comment.
Terry, thank you. I have one question, again, because of the Q&A that just took place between the two. Director Rasmussen, and I'm not familiar with this particular area of the law, but does whistleblower status apply to educators and LEAs?
That's not something I've researched extensively. I think there should be some protections there, but I haven't looked at the statutes in depth.
Just
Board
as
member
a
there.
side note, I've actually represented a couple of whistleblowers in cases involving. Pardon me.
I was you were going to
Yeah,
finish it.
yes, I had educators come to me who wanted to be whistleblowers who I represented, and usually we were able to negotiate something. I've never had to go to trial or court on an issue, but the statute absolutely applies to educators.
Interesting.
It's a pathetic statute because the timeline's so short. I mean, I've tried to do this, and you almost can't get the information in the timeline. It doesn't favor whistleblowers at all.
Okay, thank you. Your light's still on. Are you looking to say something additional?
I'm not.
Oh, okay. So with that, I want to thank everyone. We are 10 minutes over, but I want to thank everyone for coming and for what they shared, their experiences and insights. And with that, we'll entertain one final motion. All those in favor? Aye. Unanimous. Thank you.